this bill, the bill introduced by the Labour Party in the last government. So it's no surprise to the last speaker, I hope, that the Labour Party is supporting this bill. He makes it sound like we've suddenly come to our senses, when in fact, of course, this cracking good idea came from the Labour government and also from the advocacy and knowledge of Dr Emily Henderson, a Labour MP in the last Parliament. I want to recognise the work that she did. The overall scheme of the bill has been well traversed, and can I just thank the people who did come to Select Committee and submit, both those experts, the advocates, and also those who had real personal experience of litigation abuse. And I think it's one of the real conundrums of the court system that we hold very dear, this almost ancient concept of free access to the courts, and the idea that any person can come to the courts to air their grievances and seek redress. But in throwing the doors of the court wide open, that right, that entitlement can be abused. And whilst in some contexts it's perhaps not too harmful, in the commercial law, perhaps even the law of political questions that the courts might be considering, we can put those vexatious claims to one side. But when we've got people who are vulnerable, they're not victims in the sense of the criminal law here necessarily, and I was a bit perplexed by the last speaker's constant reference to victims. These are disputants largely to family proceedings, and yet it is the case that those proceedings can be used to harass, annoy, and that's not, as we noted in committee, that doesn't really pitch it high enough, because I can assure you that legal proceedings are annoying at any time, but the concept of abuse, of that harassment and annoyance reaching a level where it is intended to cause actual harm, psychological harm to the other party. And I just want to touch on one other thing, and that is, it's actually quite an important point that hasn't really been focused on, because traditionally vexatious litigants have been seen as abusing the process of the court, and the kind of party that is wrong has generally been considered the court or even the justice system or whatever. And on reflection, that's not really appropriate in the modern world, because the real person who is harmed is the litigant who is being harassed. So it's not, that's why the language was changed away from it being an abuse of the procedure of the court or an abuse of the court to being an abuse of the other party to the litigation. And I think that's a really significant and important shift. It's actually a kind of a shift of the philosophy underpinning this kind of vexatious litigant or abusive litigant problem. Because now the question isn't how is the court harmed or how is the administration of justice harmed, at least in respect of this piece of legislation. The question is, what is the degree of harm being caused to the other party to the litigation, and does it reach an appropriate threshold? And look, it's worth noting it has to be significant. It has to be more than just annoying, because the consequence is a very significant limitation on the right to go to court and ask for a remedy and to raise concerns of breach of rights or law. I think we've struck the right balance, and obviously from here this bill will be discussed further and may be subject to further improvement. But it is good that this is a bill which has crossed parliaments, crossed parties, and is still being supported around the House. So with that, I've identified those matters I did want to highlight. Once again, thanks to Emily Henderson for her work that she did, and I think she should recognise this as a legacy that she left on the last Parliament, and this one, I commend the bill.
I feel that this one is virtually bipartisan passing.
Yeah, I think it's actually really good as well to see Parliament across the table sitting there going, look, world has changed a little bit from when the last version of this was put in place, and we need to update things, because it's something that people forget a lot about our laws is, they're a stamp in time, and the world changes, it keeps moving on. So we need to occasionally update our laws to make sure that, this law might have been written pre-social media, for example, and so we want to put in protections for people on it. But it is actually really good to see bipartisan support for that kind of thing happen.
Yes, I think it's great because you have, it doesn't mean that both sides of the House have to keep opposing each other for the sake of opposition. Yeah. If there's a good bill, it makes sense, it helps the people, it protects the victims, why not?
Mm-hmm.
So there's a good united Kiwi, Aotearoan, what do you want to call ourselves, view. I mean, that we can agree to disagree, be mature about it, have a beer afterwards, and don't throw eggs at each other all the time. Well, that's a joke.
Anyways, I know he actually sat there and said to me one time he thought Lawrence Yule would be a good successor as a leader of the National Party. And it was unfortunate that he got booted out in 2020 after Tuki because they lost a good pair of hands that could take over the reins.
Right.
But that's Greg O'Connor. I mean, hey, who sits down there? You know, he's one of the few Labour people who just don't sit there and say what the Labour Party always says.